Senator Grassley.
Thank you, Mr. Chairman. General Kagan, congratulations on your nomination. It's an extremely important appointment, obviously a real honor. I also welcome your family and friends. They're obviously proud of your nomination, and I'm glad that they're here to support you. I'm committed to ensuring that this process is fair and respectful, but also thorough. The Constitution tasks our Senate with conducting a comprehensive review of the nominee's record and qualifications. You've been nominated to a lifetime position. Consequently, the Senate has a tremendous responsibility to ensure that you truly understand the proper role of a justice and the Supreme Court in our system of government. We want to ensure that if confirmed, you'll be true to the Constitution and the laws as written. We had a nice meeting in my office. You have an accomplished academic and policy background. You've excelled at Princeton University, Harvard Law School. You were an Oxford Scholar. You clerked on the D.C. Circuit in the Supreme Court. You were a law professor at University of Chicago Law School, as well as Dean of Harvard Law School. You were a lawyer here on the Judiciary Committee, and then with President Clinton's administration. You're now United States Solicitor General. Nobody can question such accomplishments. What is lacking from your background is any experience on any court or much experience as a practicing lawyer. We don't have any substantive evidence to demonstrate your ability to transition from being a legal scholar or political operative to a fair and impartial jurist. We'll need to acquire that evidence through your writings and the positions you've taken over the years, as well as your testimony. Answering our questions in a candid and forthright manner, hopefully, will fill that void. We know you cannot commit to ruling in a certain way or for a particular party. Our goal is to see if you will exercise judicial restraint. We want to know that you'll exercise the preeminent responsibilities of a justice by adhering to the law and not public opinion. Policy choices need to be reserved for those of us elected to the legislative branch of government. It's our duty to confirm a nominee who has superior intellectual abilities, but more importantly, it's our duty to confirm a nominee who won't come with results-oriented philosophy or an agenda to impose his or her personal politics and preferences from the bench. It's our duty to confirm a Supreme Court nominee who will faithfully interpret the law and Constitution without personal bias. The fact that you've been a judge is not dispositive, but because of lack of judging experience, it's even more critical that we are persuaded that you have the proper judicial philosophy and will practice it. We must be convinced that you have the most important qualification of a justice. That qualification is the ability to set aside your personal feelings and political beliefs so that you can administer equal justice for all in a dispassionate way. Your relatively thin record clearly shows that you've been a political lawyer. Your papers from the Clinton Library have been described as, and these aren't my words, a flair for the political and a flair for political tactics. You've been described as having, quote, another quote, finely tuned political antenna and a political heart. You were involved in a number of high-profile, hot-button issues during the Clinton administration, including gun rights, welfare reform, abortion, Whitewater, and Paula Jones controversies. A review of the material produced by the Clinton Library shows that you forcefully promoted liberal positions and offered analyses and recommendations that often were more political than legal. Not only that, your Marshall memos indicate a liberal and seemingly outcome-based approach to your legal analysis. You have admitted that your upbringing steeped you in deeply held liberal principles. You should know, or we should know, whether, as you've said, you have, quote, retained them fairly intact to this date, end of quote. A judge needs to be an independent arbiter, not an advocate for a political agenda. This point is absolutely crucial for justices, since the Supreme Court isn't as constrained to follow precedent as the same extent as judges of lower courts. You will have the final say on the law. You've been a prominent member of the President Obama's team. In nominating you to be an Associate Justice, President Obama clearly believes that you measured up to his his judicial empathy standard, a judge's ability, in other words, to empathize with certain groups over others. Indeed, President Obama said that you credited your hero, Justice Marshall, with, quote, reminding you that behind the law there are stories of people's lives as shaped by the law, stories of people's lives as might be changed by the law, end of quote. This empathy standard has been soundly rejected because it endorses the application of personal politics, a preference and preferences when judges decide. It encourages judges to usurp the functions held by the executive and legislative branches of government. A judge or justice must unequivocally reject that standard. It does not comport with the proper role of a judge or judicial method. We all know that's not what our great American tradition envisioned for a role of the judiciary. I'll be asking you about your judicial philosophy, whether you will allow biases and personal preferences to dictate your judicial standard. You once wrote that it, quote, is not necessarily wrong or invalid for judges to, again, quote, try to mold or steer the law in order to promote certain ethical values and achieve certain social ends, end of quote. You've also praised jurors who believe that the role of a judge is to, quote, do what you think is right and let the law catch up. And again, another quote, bridge the gap between law and society. To me, this kind of judicial philosophy endorses judicial activism, not judicial restraint, and hopefully what you've said before is not how you would be in regard to these quotes when you get to the Supreme Court. I yield back the balance of my time, but ask permission to put a longer statement in the record.